YouTube's agreement has been written in such a way, and they've gone to court in such a way to enforce the agreement by saying that they have the sole discretion to do anything. And you can even see in their language there from that paragraph in the complaint here that they believe that they have the sole discretion to evaluate DMCA counter-notices and decide which ones are legitimate and which ones are not. I disagree. I don't think that even if they put that language in there, I don't think that they actually have any discretion.
This is a community-supported legal education channel. Find out how you can support our mission at the links in the description below.
Thank you to Joshua Davis and TandaPay for sponsoring Lawful Masses in the month of September. You can visit TandaPay.com for more information about TandaPay's social insurance program, a peer-to-peer insurance program that uses blockchain technology. It's very, very cool, very, very advanced, and we'll be doing a video on it later this month. So thank you very much to TandaPay for sponsoring our videos for the month of September. All right, what you're looking at is Eric Mishiev, otherwise known as DJ Shorty. So Eric Mishiev, DJ Shorty versus YouTube Entertainment Studios for breach of contract, intentional interference with prospective business advantage, interference with contractual relations, negligence, negligent interference with prospective economic relations, and injunctive relief. And this is against YouTube, so this is yet another sort of YouTube, either DMCA or counter notice or misrepresentation or monetization lawsuit. And we'll see what's going on right now. Plaintiff Eric Mishiev operates Hot Forever LLC from Tampa, Florida, and he's suing YouTube, and he's going to amend the complaint with the names of any John Does, etc., etc. And we'll just skip all of that. He does allege the amount in controversy exceeds $75,000, which is more or less all he has to do. Plaintiff is a well-known journalist and DJ known as Shorty, that's a short SHORT-E, publishes original music, DJ mixes, and celebrity interviews. He explains what YouTube is and says that plaintiff has developed the DJ Short E Hot Forever and the Short E Show YouTube channels with over 250,000 subscribers, 110 million views, and about $310,000 in revenue over a 5-year period. A true and correct copy of his earnings is listed in Exhibit A. Okay, we can check that out if we want to. Plaintiff entered into a written agreement through YouTube's terms of service, I guess, to begin monetization of his videos back in 2007. The written agreement states the terms. He's provided the agreement. He earns money and has supplemented his income. He also books DJ events, and his earnings have generated money from the YouTube account through his AdSense publisher account. This is all sort of standard fare right now, right? March 11th, 2016, plaintiff began receiving copyright claims on his highest advertisement revenue videos, which, if unresponded to, would leave a strike on plaintiff's channel, with 3 strikes resulting in the discontinuance of plaintiff's channel. Plaintiff ended up responding by following the counter-notice procedure challenging the claims, and ended up winning all claims asserted against him, which resulted in all of his targeted channels and videos being reinstated for monetization. The content creators on YouTube understand that it is customary for false and erroneous claims to be made by others in order to intercept advertisement revenue and or have legitimate content removed to stifle competition. In order to combat such customary practices, YouTube has a requirement that the claimant provide either proof of a lawsuit for infringement or the alleged offending video will be reinstated and the strikes removed. These rules and laws are in place to vet legitimate claims from meritless claims, as well as to thwart abuse of the DMCA. In 2017, YouTube congratulated plaintiff on his success of reaching 100,000 subscribers. Congratulations on that. Thereafter, although plaintiff's channels and videos were reinstated and his subscribers were continuing to increase at a rate of about 4,000 a month, his views on each video posted remained low when compared to similar channels. Now here's the thing. We noticed the same thing too. We are also struggling with our growth stopped. We hit 100,000 and then all of a sudden our growth stopped. And even though we've now been creating daily videos for 2 months, our growth has entirely stagnated and plateaued, and so have our earnings. So it's a little weird. We're not sure what's going on. We're not sure what to do about it. Is it that we've somehow stopped competing, that others just suddenly got so much better than we did? Or is there really something going on with the algorithm that, or YouTube's policies that we don't realize we've been shadow banned or something? So we feel the same way. Like we feel like this guy. Like, did this guy get shadow banned by YouTube? Something's happening to us too. YouTube failed to provide any kind of confirmation about suspicious activity, the stagnation of the video views, saying that they could not share this information. When a person establishes a YouTube channel, YouTube has each person agree to their terms and conditions in writing, and they've attached those. They're saying that YouTube breached Section 6F of the agreement because it failed to process audiovisual content uploaded by plaintiff in accordance with YouTube's data processing terms. Particularly, YouTube's continual technical difficulties were the result of a breach in Google's security, which led to the accidental or unlawful destruction, loss, alteration, unauthorized disclosure of, or access to customers' personal data on systems managed by or otherwise controlled by Google. As a result of the breach, although plaintiff was growing at a rate of about 4,000 subscribers a month, when he uploaded a new video, he would only receive a few hundred views, directly causing a reduction in his revenue in the amount of approximately $125,000 in losses over a 3-year period. Thereafter, due to YouTube's ongoing breaches and negligence in handling plaintiff's technical issues, plaintiff lost trust with YouTube's support team and placed them on notice several times that he would be filing a lawsuit if such conduct persisted. On December 14th, 2018, YouTube sent plaintiff a notice that they were terminating his accounts and removing all of his videos due to his litigation threat, though he had not violated any rules or terms of use nor the YouTube community guidelines. Wow. So they appear to have terminated his account because he made threats of a lawsuit. Now, I don't know if you've ever called customer service and just gotten a little bit too hot. Sometimes, okay, so maybe younger Len said some things about how, if you don't want to help me, I'm going to sue you. Well, most of the time they just say, I'm sorry, sir, we can't, speak to you any longer now that you've threatened a lawsuit. You'll have to go through our legal department. Here's the phone number. Have a nice day. And then, of course, the legal department doesn't want to talk to you either. They just tell you, okay, let us know when you file the lawsuit. Have a nice day. So is that retaliation, or is that YouTube covering its butt because you've threatened a lawsuit and now at least they know that you're a potential adversary in a lawsuit? I don't know. It seemed like there was still an agreement, but YouTube does have the right to terminate whenever they want to, right? But now here they've done it for the stated reason of your lawsuit. Well, a lawsuit is just you trying to enforce your rights. It's the preferred way for you to enforce your rights rather than going after someone with like violence or something. I mean, like, in other words, we have a legal system because we are a highly civilized society, and we recognize that if we didn't have a way for you to resolve your perfectly legitimate complaints, that you would resort to some vigilante justice, and it might be either violence or something illegal or something that's maybe not as targeted as a lawsuit against a specific individual. So we don't want that. We want to encourage the adjudication of claims through a civil process so that we don't do anything vigilante, etc. The plaintiff continues. December 15th through January 15th of this year, plaintiff was abruptly bombarded with copyright claims, the likes of which he had never seen. On about January 22nd, acting upon a takedown notice delivered by claimants pursuant to the Digital Millennium Copyright Act, YouTube blocked all public access to plaintiff's videos. YouTube substituted the videos with a notice stating that this video is no longer available due to a copyright claim. Once plaintiff's videos were removed, he received strikes on his account. Although YouTube stated they removed his channels and videos for copyright claims, the removals appeared to plaintiff to be in retaliation for his placing them on notice that he would be filing such a lawsuit. Such removals violate 8B of YouTube's agreement, which states, unless the copyright claim owner files an action seeking a court order against the content provider, member, or user, the removed content may be replaced or access to it restored in 10 to 14 business days or more after receipt of the counter notice at YouTube's sole discretion. The YouTube agreement requires that any claimants who make copyright claims demonstrate that they have filed a copyright infringement lawsuit. Should the claimant fail to provide proof within 14 days from a counter notification, the claimant, remember this is the claimant, not the person who is being claimed, not in this case the DJ Shorty Hot Forever YouTube channel. Should the claimant fail to provide proof of a counter notification lawsuit, the offending video shall be reloaded and the strike removed. Plaintiff complied with YouTube's terms and conditions of use and submitted counter notices on the following dates. Although plaintiff has been compliant with YouTube's agreement for counter notifications and had previously succeeded in challenging all prior claims with no litigation ever initiated, YouTube failed to process plaintiff's counter notifications, at first stating that such counter notifications were ineligible without providing any reason why. After further inquiry as to the root cause of plaintiff's inability to exercise his procedural rights to process counter notifications, YouTube personnel retracted their statement that such videos were ineligible and instead stated that the video's counter notifications would be processed, to which they were never processed through. YouTube failed to comply with other parts of the agreements that say strikes expire 90 days after they were issued. 90 plus business days, wow, have passed, and YouTube should have organically removed the strikes, and they have not. To date, plaintiff's strikes have not been removed, his counterclaims have not been processed, and his videos and channels have been permanently removed, though no claimants presented evidence that they filed any lawsuit, thus evidencing that YouTube did not simply remove his content because of copyright claims, but instead in retaliation for placing them on notice that he was filing a lawsuit against them. YouTube breached their agreement by removing public access to his videos, failing to reinstate all of plaintiff's videos, failing to remove the strikes from his channel, and failing to reestablish all of his channels. And then, of course, this is all going to be AdSense damages, 90 plus thousand, 720,000, and they allege a breach of contract for 720,000, interference with a contract against probably YouTube and the John Does, interference with economic advantage, negligent interference with economic advantage, negligence in general, and ask for injunctive relief. And this is, I'm really actually super excited about this because I was looking for this case. I've been looking for this exact case for a long time now. I, as an attorney, have seen potential clients wondering why and asking for my help in getting YouTube to process their counter notifications at all. YouTube seems to have stopped processing some or all, I don't know whose or why, but they've seemed to have stopped processing counter notifications for people who have been claimed by false copyright strikes. I recently had a client whose website had been claimed, and Google, not YouTube, but Google, gave us a hard time. And instead of taking 10 to 14 days, they took 45 days to respond. And when I post on Twitter asking for armchair lawyers, including real licensed armchair lawyers, and I don't mean it as an insult, but they're making a legal statement or making an opinion or something on Twitter in response to a very, very dumbed down hypothetical. But the response has been that they don't see any liability for YouTube or Google to simply not process a counter notification. Well, then what the heck is the law for? So I'm still pounding on the table here, trying to find some kind of liability on YouTube's part for not processing a counter notification. Because remember, a person gets a claim from a claimant. The defendant has to file a notice with YouTube that says that they believe that they're not involved in copyright infringement, and then that original claimant has to go to court. That second step there, forcing the original claimant to go to court, is called a counter notification. It's the second or responsive notification. Well, there's a law about that. DMCA 512 says what you're supposed to do to format a counter notification, put the right information in it, and send it off. And many times we've had questions, well, do you have to put your real name and address on it? Because then you're revealing your real name and address to a potential plaintiff who might not know who you really were until then. DJ Shorty might not have revealed what his name was, absent this kind of claim. So there's gotta be some kind of liability here. There has to be some kind of liability here. And this is probably the first case that's ever asked for a judge to assign that liability. So we're going to find out. And I'm really excited about this. So we're going to be following this case very closely. And I really hope that YouTube is found to be liable for not processing counter notifications as they're supposed to do. One other thing that YouTube has been doing is they've been indemnified, or at least we suspect that YouTube has been indemnified by the major music corporations, the recording industry, UMG, BMG, EMI, Sony, etc. That these companies are now telling YouTube, just don't obey the counter notification process, and if you get in trouble, we will pay for it. Well, that seems like some kind of interference with contractual relations now. If Sony is buying YouTube's interference with my DMCA counter-notice process, this is pretty shady and shouldn't be allowed. And I don't understand how Susan can go say things all about the YouTube community and we're improving it, we're making it better for creators and all that, when they do this, failing to obey the very basic law of copyright infringement counter notification processes. So let us know what you think about that one in the comments below. I think this is a great lawsuit. I have no idea whether these claims will actually survive because YouTube's agreement has been written in such a way and they've gone to court in such a way to enforce the agreement by saying that they have the sole discretion to do anything. And you can even see in their language there from that paragraph in the complaint here that they believe that they have the sole discretion to evaluate DMCA counter notices and decide which ones are legitimate and which ones are not. I disagree. I don't think that even if they put that language in there, I don't think that they actually have any discretion. The law does not allow them to have any discretion. The law says if you want to have a safe harbor, you don't break the counter notice process. If you want to have the safe harbor, you have to follow the counter notice. So they're no longer in their safe harbor, and they should be liable for this infringement of the Section 106 copyrights, the right to control publication, distribution, etc. And so YouTube is now in some sort of conspiracy. I don't mean that in like a flat earthers or we didn't land on the moon kind of conspiracy. I mean they're working with the conspirators, the other parties, rather than obeying their agreement and the law in favor of creators. What the heck is that about? So tell us what you think in the comments below with that one. Thank you very much for joining us. I'm Leonard French, your favorite copyright attorney. In the virtual studio with me today has been Brandon, our community manager and video editor. Thank you very much, Brandon, for all of your hard work. We are taking Brandon full-time at the end of the month, and this is very scary to us, so please, we could really use your donations. They will go directly to keeping Brandon employed as our full-time editor and keeping him from having to do a different crappy day job that I'm not sure that he really enjoys all that much. So thank you to all of our supporters this month. Especially thank you to TandaPay and Joshua Davis, who are supporting us at the $1,000 level. We will be making a TandaPay video for Mr. Davis, and there will be a sponsor spot at the beginning of all of our videos in place of our normal sponsor spot. Thank you very much to our $50 plus supporters: John Steele, Gavin Barnard, Kyle Mudrak, Eevi, Michael Pearce, Spirit Bear, Jan Negrey, Daniel Perez, Snorre Wisotzky, Joe Tyson, and Blackleaf. Thank you very much for all your support in the month of September. And thank you to the $5 plus supporters who will be scrolling on the crawl. Thank you so very, very much for making this possible. Love you all. I'm Leonard French, and I'll see you in the videos that drop. Have a great week. Bye.